It may be granted to file the ability opposition beyond 2 days' time, my brother.
Which matter is it?
On matter, you are not to pass an order on 8 June 2026.
Yes.
Direction upon the division to file ability opposition respondent within 4 weeks.
There, you file it when the matter is listed, or move an application for condonation of delay for filing.
Then praying for leave, Malad, to draw up the judgment, Malad.
Malad, I'm praying for leave for draw up and complete the order.
State matter item number 1.
If this matter has been settled between the parties, I am praying for withdrawal. The matter all interim.
Learned counsel for the petitioner states that the matter has been amicably settled between the parties. Copy of the instruction received from the client to withdraw the present petition is taken on record. The present petition is dismissed.
Item number 2.
May please, my lord. My lord, while I am led by my lord, learned senior, may I begin making submissions, my lord, with my lord's leave? My lord, this is my execution. My lord, if I may give my lord a brief background. My lord, this matter, my lord, stems from, my lord, an award, my lord, passed by a learned tribunal, which left me, my lord, as an award debtor. My lord, this was challenged, my lord, in a section 34. Analogously, my lord, they filed their, my lord, the respondents filed their execution. My lord, this execution was allowed. My lord, the 34, my lord, the judge order as it arose from the 34 is, my lord, being reviewed. My lord, we have filed a review. My lord, there are further subsequent appeals. However, I'm not going into that. As on date, my lord, they have received, my lord, the fruits of the award in as much as, my lord, they have received conveyance as a result of the execution. Now, why am before my lord, my lord? So, my lord, to clarify, my lord, there's no scope for an interim order. My lord, so I'm not asking my lord for an interim order. But why am before my lord? My lord, I'm led by Mr. Oh, so
they should no. I'm not. I'm opposing. I'm sorry, my lord. I'll just not come to vote physically, my lord, in 10 minutes. My lord, they should explain how it is maintainable, my lord. That's all I'm on. I'll just, my lord, be there, my lord.
Very well. Look, why am before my lord? The deed or the document that was executed pursuant to the execution. My lord, my submission is it is not in terms of my lord, the order, my lord, the order of execution, and not even my lord, in terms of the draft settled by the registrar prior to execution. That is why I'm before my.
But why execution petition?
My lord, the section 45, my lord. It's a question arising of the execution, my lord. I have no other, my lord, avenue in this regard. My lord, my humble submission is that affidavits may be directed if they have, my lord, a question of maintainability. My lord, they can raise that. My lord, affidavits, since there is no scope, my lord, for interim orders, my lord, submit that. But affidavits may be directed.
My lord, what is he asking for execution? I don't know. Let him first, my lord. It's not a question of, my lord, having it pending before the court, my lord.
My lord, may come to, my lord, my tabular statement. My lord, please.
Yes.
My lord, I am, my lord, asking for, my lord, that deed which has been, my lord, executed to be, my lord, cancelled.
This is not
that is my relief. My lord,
not the proceeding.
Yes. My lord, this is section 45.
No, but this can't be a proceeding.
47, I apologize, my lord. I've been
this
saying.
Can't be. This
My lord,
can't be.
it is a question, my lord, arising out of an execution proceeding. I have, my lord, no other scope. That is my submission, my lord.
Read 47.
My lord.
What is 47?
My lord, questions to be determined by the court executing decree. All questions arising between the parties to the suit in which the decree was.
47 of
My lord, I'm referring to the civil procedure code. My lord, I should have been clear. I apologize.
But my lord, before my learned friend takes, my lord, through section 47, this is an award in respect of which he is seeking an enforcement, and
Yes.
for that it should have gone under 36 of the Arbitration Act.
yes.
My lord, there are two. I am, my lord, also seeking, my lord, execution with respect to, my lord, an undertaking given by them. My lord, they had,
Show it
yes.
from the document, sir.
My
You're
lord,
just making those bold
My lord,
statements.
my lord, I will. May I, my lord, please, undertaking, first take out. Yeah. My lord,
Tell me,
if,
what do I need to see right now?
my lord, my lord, the affidavit in support, my lord, may I just show the undertaking? My lord, may kindly take page 36.
Part of the award with your
And if I may indicate, my lord, what I'm showing, my lord, is, my lord, a portion of the award where, my lord, the order recording the undertaking is reproduced. If I may, my lord, please. My lord, may kindly come to page, my lord, 37, where, my lord, the text of the order starts. The court, may I please, my lord? The court, in view of the earlier order passed on 10th February 2000,
Where are you reading? Page 37.
my lord,
Which line?
my lord, I'm from the beginning, my lord, the court, my lord,
Volume 1.
my lord, volume 1, my lord, has.
Here.
My lord, I believe there might be two page numbers, a handwritten larger page number. Sorry.
Yeah.
My lord, I'm led by Mrs.
Yes, Mr. Tucker.
Your lordships have recently delivered a judgment, my lord, where your lordships declined to enforce an award in which the appointment was not made in accordance with law. Here, my lord, it's not even that far. Here, my lords, it is a simple case that a decree has been executed. Award has been directed to be executed. It was a suit for specific performance. Not suit, the reference was for specific performance. Resulted in an award against me directing execution of a conveyance to transfer property. Conveyance has been executed. R34 was unsuccessful. Conveyance has been. Only short point is, my lords, whether the conveyance which has been executed is in terms of the decree made or the award made and in terms of the draft which is settled by the registrar. So, my lord, no other suit lies. No suit lies for this because it is an act done in execution. And this is the only recourse which is available. In execution, a decree is prepared by the department pursuant to orders of court, and the decree is the conveyance is registered. Now, my lord, if there is any anomaly in the document which is registered, that your lordship and lordship only has the jurisdiction. Nobody else can touch it because it is an act done by department of court pursuant to a decree made by this court now, and, my lord, pursuant to orders of court.
What is the anomaly?
Beg your pardon, my lord.
What is the anomaly?
Your lordships will kindly have the conveyance once. Only on the prima facie thing, I'm just showing your lordships what was the conveyance which was approved by the registrar and what is the document which is ultimately executed by an officer in the department of the registrar. Kindly have page 318, please, my lord.
Volume?
318, volume 2, please, my lord. Volume 2. I think no enough.
Lord, kindly give me, my lord, 10 minutes. My lord, I'll be there. My lord, I'm so sorry. I'm just excusing myself for 10 minutes. I'll just come, my lord. I'm so sorry.
Yes.
Now, my lord, this is the certified copy of the draft deed of conveyance. Kindly see the date, please, my lord. 318. Kindly see 318 is the letter by which, my lord, the award holder filed the draft conveyance with the department at 318, and this is the certified copy which we obtained. Kindly see 319 now, please, my lord. This is the draft which they filed. Now, in this draft, kindly come to
Page schedule of the property itself. Kindly come to 332.
P32.
Yes.
Yes.
But for convenience, may I bring your lordship to 338 because I've prepared a chart. Instead of taking your lordship back and forth, I've prepared a chart of what is the divergence. Kindly come to page 338, please, my lord. Kindly ignore 1 for the time being. Kindly see 2. Kindly see 2, where the description of the person who's executing it on behalf of the award holder changes. But that is also not very material. What is material is, now kindly come to 339. A word is inserted. Kindly see 339. Now this is as per the draft which is approved by the registrar. The vendor has today delivered, handed over the physical possession of the scheduled property to the vendee. This is what the registrar has approved. Now kindly see the document which is executed. The vendor has today delivered, handed over vacant physical possession. A word is inserted by the award holder in the document which is prepared by him for registration, adding the word vacant. And the departmental officer who is only going to sign on the approved draft which is approved by the registrar, he signs on this document. So this changes the whole nature and character of what is being handed over. 1. Now kindly see the consideration amount. It was mentioned 15 crores and then 8 crores 15 lakhs.
Amount has not changed. 15 crores is the same one.
Yes, my lord, it is 8 crores. Kindly see the amount which was there originally also. This is the draft which is approved. 8 crores, 15 crores only. This is not a, this is basically an anomaly, couldn't be there. And then kindly see annexure A1. A1, annexure 1A was not part of the deed which was approved by the registrar. And annexure 1A, a new document has entirely been enclosed. I'll just show you, lordship, what is 1A. But what is significant on this page is vacant. Yes. Property is not vacant. It is encumbered. There are trespassers. There is land acquisition. There are the old workers are there. Families are there. All that is there. That is one part of it. And second part of it is annexure 1A, an entirely new document goes in, which was not approved by the registrar. So this could not have been done, my lord. After the registrar has approved the draft, one cannot make any changes in the document. Kindly have the deed of conveyance now which is registered. Starts at 340 is the stamp. And your lordship will see that these incorporations have been made after the draft has been settled by the registrar. 3. They shouldn't have put the stamp pages. No, why did you put the stamp pages? Kindly have, please, my lord, page 362. Kindly see paragraph 4 at page 362. I'm sorry.
Yes.
Paragraph 4 at this page, 362. The vendor has today delivered or handed over. Now kindly see, vacant physical possession of the scheduled property to the vendee. And kindly have page 329 once, please, my lord. In what was the draft which was approved? 329. Kindly compare this paragraph with page 329, paragraph 4. The vendor has today delivered, handed over the physical possession. The word vacant has been inserted. And kindly have, my lord, 374, please now, my lord. And you have 374.
So you are the vendor.
I am the vendor, but it is executed through the registrar because I was challenging so I did not register the default. In default, my lord, the department registers it. Now kindly see 374, please, my lord. These are the new pages which have been inserted. All these details which are put in here, this is an entirely new document because your lordship will see what was approved by the registrar, of which we obtained a certified copy, ends at 334, 335 and 336. This document, if it had to be executed, irrespective of what the contents are, it has to be approved first by the registrar. It cannot be done without the approval of the registrar. These are, my lord, my limited. And kindly see the drawing also which is there. Kindly have 335, the map at 335, which is the map approved by the registrar. Now kindly compare the map at 335 with the map which is finally registered, forms part of the registered document at 372. Kindly compare 335 with 372. 335 is what is approved by the registrar, 372 is what is executed. So an officer, my lord, who is only deputed for the ministerial task of putting his signature on a document cannot, my lord, make changes. Then the whole purpose of the reference and the approval given by the registrar is frustrated. This is going beyond his authority. So 3 changes, my lord. One is your lordship has seen vacant. Second is the map. And then third is 374. And I have, my lord, no remedy other than this because the suit does not lie. Yes. It is only because it is an act done by department of the court over which the executing court, your lordship in chambers, has exercises authority. So this is the only mode of redress, my lord.
Yes, Mr. Chair.
My lord, another 9 proceedings. We'll reach from, my lord, A to Z. Please have a look at this chart. And then I'll show your lordship. He's, my lord, on the same from the award. Please give him a copy. He's reached up to Q on the same issue. My lord, Can Oh, I'm sorry, my lord. That was meant for me. I must have written something later. I'm very sorry, my lord. My lord, if your lordship sees, my lord, this chart, he's reached from, my lord, A to Q. All connected with the same award.
That's all right.
Now, my
Mr.
lord. Oh, Mr. Banerjee is here.
I'm sorry, just one, Mr. Chaudhary, you can, I'm sorry, I'm stuck here. My lord, just kindly look at 2 things. I'll then, my lord, give it to Mr. Chaudhary. One, my lord, on the question, my lord, this is not in the execution application. This application is not in the execution application. This is made, my lord, in a section 11 application. That's first. Kindly, my lord, look at, my lord, the cause title. Second, my lord, all the orders, my lord, were confirmed by the learned judge, my lord, by a 7 January 2026 order. And, my lord, they have preferred an appeal before, my lord, a division bench with regard to the same issue from some of the orders. And, my lord, we'll have the division bench order, my lord. I'm sure Mr. Chaudhary, my lord, will show that.
Yes, yes, sure.
I'm so sorry, my lord. Kindly, my lord, pardon me, my lord. I'm Mr. Chaudhary, all.
My lord, just what Mr. Banerjee had mentioned, if your lordship permits me to show, my lord, 7 January 2026 order. So, my lord, there was an award, there was an execution filed. In the execution, this is an order passed. My lord, please see, my lord. There's an order, my lord, passed directing execution of conveyance. Then matter comes back before the learned judge. And, my lord, 7 January 2026 order is passed. My lord, may I just read it? I copy them. It is submitted by Mr. Banerjee, learned senior counsel, that in view of the judgment passed by this court, sale deed has been executed and registered in favor of the award holder.
Report with regard to the same is submitted by the learned registrar in charge. Same is taken on record. Next page, my lord, is the I'm sorry, my lord. Next page, my lord, is the report. If your lordship sees the report, second paragraph, the undersigned most humbly submits before your lordship that a note dated 18 December 2025 was submitted by the undersigned, that's the registrar, upon perusing the same by an order dated 19 December, flag B. Your lordship was pleased to direct SBPL Infrastructure Private Limited award holder to assist the undersigned to compare the deed with the map and the schedule with the award as well as Exhibit C22. Your lordship was further pleased to direct the undersigned to comply with the order passed by your lordship for registration of the deed with proper verification of the said document by 7 January 26. By a subsequent order dated 22nd December 25, your lordship was pleased to modify the previous order dated 19 December 2025 and direct inter alia as follows. Conveyance, Lord, please see the next page. Second paragraph of page 2, written on page 10, be read as page 102, and thereafter following sentence be added, that is, being conveyance deed dated 8 July 2010. The map is at page 130 in volume 7. Other portion of the order dated 19 December 2025 shall remain unaltered. Undersigned further submits before your lordship the following facts in connection with the present reference proceeding. Now, my lord, I submitted first paragraph, subpara, I submit. Then the map plan is also available. That's considered. On 24th December 25, during the reference proceeding, it has been found that the documents mentioned by the Honorable Court is available in the paper book. Map plan is also available. Hence, the reference clerk was directed to compare the draft map plan submitted with the draft deed of conveyance with map plan available such and such. Then, my lord, accordingly, the draft deed scrutinized, corrected, my lord, with the map. Then, my lord, fourth bullet point, by another order dated 2nd January 2026, draft deed of conveyance along with a map plan as submitted by SBPL on the self-same date was approved by the undersigned since the same was found in order after scrutinization in compliance with the order dated 24th September 25 passed by the Honorable Court. Map plan was made part of the draft deed of conveyance. Then market value assessment and ultimately, my lord, execution. So, my lord, this report came before the learned judge. Now, these orders, my lord, which are referred to in the registrar's report, these were challenged before the division bench of this honorable court. Yes. Resulting in a judgment of 18th February 2026. Lord, please have a look at paragraph 36.
Yes.
This is our submission regarding the map. Now, my lord, from paragraph 39, the consideration of the division bench. And then, my lord, please come to paragraph 59. So, everything, my lord, considered. And paragraph 97, my lord, has the direction. My lord, paragraph, if I may place page 31, paragraph 97.
Yes.
Thus, my lord, middle of the paragraph, fourth line. Thus, in order to give complete effect to the award in letter and spirit, it was necessary for the draft deed to be compared with the map and the schedule, not only with the award, but with exhibit C22 as well, which was the map annexed to the original conveyance deed, dated 8 July 2010. The powers so exercised by the learned single judge were well within the periphery of the power vested in him by Order 21, Rule 34(3) of the CPC. The ministerial tasks of comparison between the maps, the schedule, and the draft deed, as well as other ancillary procedure, were left to the registrar. However, the learned single judge did not shirk his duty, but duly directed the reports of the registrar containing the altered draft deed and including reports as to the comparisons with the map, etc., to be placed before the court on every occasion. Only after perusal of the reports placed before the court, as evident from the impugned orders, the orders in respect of alteration of the draft were placed by the court from time to time. Finally, upon such draft being finalized, it was directed to be executed and registered before the Registrar of Assurances, Hyderabad, in terms of the award. And that's all happened. Hence, none of the arguments of the appellants are tenable in the eye of law. Now, my lord, this is regarding map. So, my lord, may I just put it in sequence? Number one, execution application filed by me for execution of the conveyance in terms of an award for specific performance passed by the learned arbitrator. Execution is taken up for consideration along with section 34. Section 34 is dismissed, execution is allowed. The learned judge, my lord, taking up the execution matter, directs a reference to be initiated, considers the matter, the report of the registrar, compares and has, my lord, the draft deed and the map placed before his lordship on every occasion, then finally says, please proceed. And, my lord, deed is, my lord, executed. Challenging these orders, post execution being allowed, directing, my lord, execution of conveyance, the 3-4 orders, my lord, comparing map, my lord, supervising the deed to be, my lord, finalized, these are taken up in appeal before the division bench. Division bench dismisses his appeal. There is no section 37 filed till today. There are, my lord, host of reviews. Last one was yesterday. Allegation was learned senior counsel, my lord, leading us in the matter, leading me and Mr. Banerjee both, my lord, misled the court, didn't argue, and judgment was delivered from this 18th order, because he'll, my lord, immediately tell your lordship I filed review. So that was the ground of review. We've got, my lord, now we have everything on YouTube. We'll, my lord, show that everything was done, but this is how bad it is. Now this is brought to your lordship, and, my lord, none of this is shown. None of this.
What the word vacant possession?
Yes, no, let me explain that. This is, my lord, an undertaking contained in a section 11 order.
No, what he is trying to show is that the deed of conveyance which has been decided before the registrar and the one which has been executed, there's a difference wherein the word vacant possession has crept in.
Yes.
In the draft which has been finalized to be
But
executed,
it's not approved. It's approved by division bench.
the draft is approved by the division bench.
Yes. By the learned single judge, those earlier orders, my lord, went up. This is approved. And it can't be done in a fresh execution.
The one which is approved has the word vacant.
Show me the approved draft. Now, my lord, may I just say this?
What he is contending is that the one which has been approved has only got the word physical in it. The word vacant has been interpolated, added to
Interpolated.
added
Behind the back of the register.
Behind the back of the register, it has been done. My lord, so what is, my lord, he therefore has to, my lord,
Copy, no, of the one which was
he
approved.
therefore has to go and he has to challenge it appropriately, not by filing a fresh execution. My lord, see, my lord,
Challenge an act done by the High Court.
it's been executed by the assistant registrar. So behind the assistant registrar's back, I go and change the document, then the assistant registrar signs. Unbelievable.
That is the case.
Now, now, my lord, please have a look at the.
Show the certified copy.
Now, please, my lord, see the tabular statement. Please see the tabular statement. And my lord, see section 36. Prayer A, my lord, is declaration that the deed of conveyance is void.
Yes.
This is fresh execution of an award. So, my lord, declaration that it's void. B, delivery upon cancellation of the deed of conveyance. And D, to direct the registrar to execute a deed of cancellation of conveyance. A and B, let my learned friend show from section 36, my lord, is important. Please see section 36. It says, let the award be executed as if it is a decree. So, my lord, assuming my learned friend is correct, I've just asked them to take out 2 orders. Assuming my learned friend is correct, he has to apply in the previous execution.
Not only apply in the previous execution, Mr. Thakkar, you need to go before the learned single judge where he has approved of the conveyance deed. And if you think that the approval of the conveyance deed is contrary to the one which has been executed, let the correction be made by the.
I bow down to you,
judge.
Lord. May I just show that this is not approved by the learned single judge also? May I just trouble
Go
you?
before him.
This is not what is approved by the learned
You go
single judge.
before him.
Can't be by a fresh execution.
You go before him that his order has not been properly carried out. But a fresh execution can't be done. You have to go before him. This can't be done in execution. Sorry.
It has to be done in execution, but
No,
maybe
sir, it can't be done in execution because if you are aggrieved by any of the orders which have been passed by the learned single judge, wherein a draft conveyance deed has been formulated, but you see that there is a change in there, go before the learned single judge. Tell him that his orders have been flouted. Tell him that it has not been complied with.
very well, ma'am. Has to be done in. I understand what is troubling you, Lordship. Maybe has to be done in the same execution that I follow, ma'am.
Yes.
Then kindly grant me leave to withdraw, ma'am.
Learned counsel for the petition seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law.
Great.
No, tongue in cheek, my lord. Now we'll have ours.
My lord, if any of this A to Q was relevant, my learned friend would have given the prayers in the notice of motion.
I am
That's why I said-
I'm not
Just
concerned
to
with A
put
Q.
tongue firm
I am-
in the mouth.
I am grateful to Mr. Thakkar. It's a rainy morning. I have nothing to do. He's given me something to do. I'm like grateful to you. Why are you taking it otherwise?
Grateful, ma'am.
Grateful. man.
Witness has withdrawn.
Not three.
Your Lordship, in this matter, I am appearing on behalf of the petitioner. Your Lordship. For starting the matter, I have on prayer before your Lordship that in this application, the awarding amount was inadvertently mentioned, which should be corrected, and therefore I'm listening before your Lordship to kindly grant leave to withdraw this application and
Learned counsel for the petitioner seeks to withdraw the present petition. That same is dismissed as withdrawn with liberty to file appropriate proceedings in accordance with law.
if you I am appearing on behalf of the award holder, Your Lordship.
I believe I'll be appearing for the judgment debtor, the award debtor. I believe, my lord, because I've not been served. But I can only point this out, my lord, only one point, if your lordship kindly allows me before he starts, my lord. 2014 award. 2022, my lord, I say I get to know because I have been asked to act in terms of the award, but I have not been served with a copy of the award. I file a section 34 before the Bombay High Court, my lord. Now, my lord, that is pending. Now, there I believe my learned friends have moved a section 9 application, where, my lord, I think there is an order, there is an order which says that the section 9 court can do nothing, but it has sought to ask me to disclose on affidavit my assets, which again, my lord, we believe is beyond jurisdiction. So, my lord, we are preferring an appeal from there. Now, this has appeared today, my lord. I have not been served. On the face of it, means beyond 2 years, my lord. Only if he could serve me, and I can come back tomorrow, my lord, or day after, whenever your lordship keeps it. Because it's admittedly it's beyond, my lord, 2 years. I hope you agree to that.
Admittedly beyond.
The award is beyond 2 years. Well, it's recorded in the judgment of the learned single judge of Bombay.
Yes, that I am not. That I am not
Let me
disputing.
be
It is
served.
beyond 2 years.
Let me-
But your lordship, on the last occasion, had inquired from my learned friend that as to the limitation point, your lordship, to satisfy that to your lordship, may I file a supplementary which is ready with me, your lordship, only to add certain documents which will show that I have filed this execution proceeding within the limitation period. May I file the
Within the limitation period means you have filed it within 2 years.
No, your lordship.
Beyond 2
Within
years,
the
12 years,
12
12
within
years.
12 years.
12 years. Bombay High Court says it's just within 2 days of limitation expiry.
So if the Bombay High Court has already taken a copy,
Yes.
But the Bombay High Court has
May I-
disposed it of, my lord, saying that I cannot do anything else.
Only taken a prima facie view.
Yes, that's a prima facie view that has
And
been
said
taken.
that
my
the
lord.
section 34 court will
Whatever
take
there is in the order, my lord, I cannot change it. So, my lord, I must tell your lordship what the Bombay High Court has said.
that's what is expected of you.
Obviously, my lord, that's why I said that let me get a service, because, my lord, I have a point that if it's not served on me, but I can take that point of 36 not being available.
All right, give a copy. We'll have it day after tomorrow.
May I serve here and now?
Day after tomorrow is a Saturday, my lord, so
We'll have it on Thursday, next Thursday.
next Thursday. My lord. I'm very
Great. I'm serving the application, execution application as well as the supplementary.
very grateful. my lord. I'm very
Supplementary affidavit filed by the award holder is taken on record. Keep it on Thursday. List on next Thursday.
grateful.
Grateful, your lordship.
Bye.
I appeal for the award debtor lordships. Kindly grants me 3 days time to file my wakalatnama and also file an affidavit in opposition. May I indicate lordships? I was the claimant in the arbitral proceedings. The learned arbitrator had directed specific performance, but we filed a section 34 within time before the learned district judge Jaipur, and also a section 9. Kindly grants me 3 weeks time to file an affidavit in opposition, bring on record those documents and all the pleadings concerning the section 34 and the section 9. And I must also point out, lordships, no stay has been granted, and that was also indicated by Mr. Gupta on the last occasion fairly, but lordships kindly grants me 3 weeks time to file my
But
affidavit.
only thing, well, this is my property is lying stuck for more than 20 years. There was a agreement between the parties where I would sell, they would purchase. Agreed consideration. Now, the proceeding had gone. After 20 years, the learned arbitrator has enhanced the consideration, granting specific performance in their favor. In the awarding portion, the learned arbitrator had indicated that 3 months' time would be available to them to pay that money, and I shall be obliged to, my lord, execute. In the event they do not pay within that 3 months, then we shall be liable to refund whatever amount they had paid by way of an earnest money. They had not availed of that opportunity within 3 months, so we have tendered the amount. So, my lord, my property is lying stuck, and as on date, there is no stay of the award. So, my lord, my right really has accrued to, my lord, pay the money off and free my property. So, my lord, this filing of section 34, even if there's an issue of jurisdiction, which naturally I cannot urge before the executing court, be that as it may, my lord, the filing of section 34 won't amount to an automatic stay, my lord. I need not trouble your lordship with the judgments, So, my lord, it's an admitted position. There is no, I'm sorry.
Anymore.
Not
anymore.
Not. So, my lord, now, so, my lord, there is no stay. If there is no stay as on date, so there is no bar in proceeding with the execution. All I seek today is, my lord, satisfaction of the, my lord, decree or the award under execution under Order 21, Rule 1. Because if the decree wants me, directs me to make any payment, I have to pay that in court as per Order 21, Rule 1. Unless under Order 21, Rule 2, by the certificate of the decree holder. So, my lord, today all I seek, and your lordship would kindly see my prayers in the tabular statement. When I had moved this, my lord, I had indicate this really no injunction on the bank account. I'm not praying for any affidavit of assets, nothing of that sort. Only that awarding portion where my obligation is there to refund that money, because the time to execute has gone. And if there is no stay, then nothing remains.
The money is with them.
It's with me. So I am, if your lordship kindly sees the ordering portion once.
Page?
Yes, ma'am. Page 86, ma'am. There's a heading called relief, my lord. Has your lordship got it? Yes. May I place it? I grant specific performance of the MOU dated such and such at a modified price as determined.
Does not have any pagination. 68. It's page 68. Thank you.
Now, the default clause just at internal page 69, third paragraph, my lord.
Yes.
Now, your lordship would kindly have a look at Order 21, Rule 1 once, my lord, of the Code of Civil Procedure. Order 21, Rule 1, my lord. Modes of paying money under decree. All money payable under a decree shall be paid as follows. Then A. I'm sorry, my lord.
Yes. Yes, modes of paying money under.
Modes of paying money under a decree. All money payable under a decree shall be paid as follows, namely A, by deposit into court whose duty is to execute the decree, or send to that court by postal money order or through bank. So, my lord, this is really, my lord, my application in terms of, my lord, Order 21, Rule 1. I have been directed to make payment under the decree when their default has already happened. So, it's my obligation now to pay the second part of the award.
But what about page 86? You see that?
I'm sorry, my lord.
This one. What about the relief portion? If you see the last line, despite offering 155 crores.
No, but that has never kicked in because they had not offered.
Just read it further.
Yes.
Despite offering 155 crores by the claimant buyer, if the respondent refuses to, they are the respondents here, right?
They are the respondents here, but here in the award, I was the respondent.
You were the respondent.
I was the respondent.
The respondent refuses to execute the conveyance. The claimant would be entitled to execute the award as a decree by getting it executed through appropriate court of law having jurisdiction to entertain the same upon deposit of the entire sum before the said court within a period of fortnight from
They have not done. So, they have not offered 155.
6.2 crores.
Which I'll have to get back. It was for them to offer 155 an obligation was cast on me to execute the conveyance. In default, this line which your lordship, my lord, just now indicated, and in the event they do not offer, my lord, I have to refund, and I have, my lord,
If we
tendered the
file-
amount.
Lordships, we filed the section 13.4 within time. We've also filed the section 9 before the learned district judge Jaipur within time. All that I'm asking Lordships for today's Lordships will kindly grant me 3 weeks time to file my affidavit in opposition before passing any orders, just to show Lordships that
There's no stay anywhere.
there's no stay, Lordships, but my respectful submission is Lordships does not have the jurisdiction. Territorial jurisdiction lies with the learned district judge Jaipur, Lordships.
Where is the property?
But I am not claiming any right in respect of the property.
Property
So,
is Jaipur.
and respondent is within.
Territorial jurisdiction in
Yes.
terms of that.
We do
This
not
is the
have any
executing
office.
court.
We do not have any office, Lordships. We do not have-
Arbitration was held here.
Arbitration was held here. This is the executing court. Why
Lordships
there's
will
no
kindly grants me 3 weeks time to file my affidavit in opposition. We are also in the process of filing section 47 application for Lordships on the aspect of jurisdiction.
in a execution? It's not a matter of right to file your affidavit in opposition.
I appreciate Lordships, but Lordships will
This
kindly
has to be
appreciate my client is based in Jaipur. We also need some time to take instructions, Lordships. My client is based in Jaipur, Lordships.
Come back next week with the instruction. But this can't go on like this. If you don't have a stay, you don't have a stay.
That's
No, they've not even applied. They have not even filed a 36.
Then
we filed a section 9 Lordships, but
Section 9 will
we have not
help
filed a
you.
section 36 to that.
Section 9 will not help you. You will not even pay the money. You will not get it executed. Then you don't
20
even
years my property is stuck. 20 years.
This can't
That's
be
because
done.
of pendency of proceedings. The 20 years the property was stuck. That's because of
Proceeding is
pendency
over
of
now.
proceedings.
The award has come. This has to be executed. I'll
Lordships,
direct them to refund the money. So
Lordships will kindly permit me to come back next week then.
to come back next week. You can't keep it like this.
But could I file the affidavit of service, madam?
Next week.
Could I file the affidavit of service?
Next week.
Next week. Great.
Not today. I'm not passing any order. Let them come back with the instruction. This can't go on.
I appreciate Lordships. Great.
And now 6.
But item number 6, Mr. Amitabh Ghosh is leading me. He has not come to court. If your lordship
Not today.
get full.
Seven.
Your Lordship, item number 7, I appear for the award holders.
Yes.
The matter has been settled. So I crave leave to withdraw this matter.
Learned counsel for the petitioner. Award holder, petitioner. Seeks to withdraw the present petition. Execution petition. The same is dismissed as withdrawn. I'm not recording settlement. Dismiss it.
Great.
8.
I'm appearing for the award holder. My lord, award made and published on 8 December 2025 within 2 years. My lord, application. 3-member arbitral tribunal. Majority award, my lord, I'm seeking enforcement of the majority award. The awarded amount is rupees 23 crores.
This is
20
within 2 years.
within 2 years, my lord.
Take
There's a section 34 application, but no stay, my lord.
The award holder has preferred the present execution petition seeking enforcement of
My lord, award dated 8 December
award
2025.
dated 8 December 2025 passed by the arbitral tribunal. Full stop. The award letter is directed to file his affidavit of assets within a period of 4 weeks. Affidavit of service shall be filed on the next date.
They have a bank account within the jurisdiction of this honorable court. I have mentioned that in paragraph 18, and they have a immovable property also. B and C, my lord, at paragraph 18, schedule A.
This is West Bengal High government. Let's
I'm
talk
grateful.
about-
Not 9.
My lord, my execution case beyond 2 years, my lord. I'm praying, my lord, for notice to be issued.
Date of award.
I'm sorry, my lord.
Date of award.
My lord, 30th September 2005.
The award holder has preferred the present execution petition seeking implementation of the award dated 30th September
2005.
2005 passed by the arbitral tribunal. Full stop. The execution petition has been filed beyond 2 years, beyond the statutory period of 2 years. Full stop. The department is directed to effect service upon the award debtor in terms of Order 21, Rule 22(1) of the Civil Procedure Code 1908. The department shall file a report on the next date. Next returnable date, give after 6 weeks.
Grateful.
Routine.
Lordship, this is my execution application. Lordship, there is an application also GA filed to my execution application. That was for the confirmation of the sale of the asset. Lordship, we had got a maximum bid of 17 lakhs lastly, but thereafter the matter was not taken up. So the bidders have backed out. Today, I have a bid of 12 lakhs against the asset. I was praying for a confirmation. Lordship, the receiver is also here. We had forwarded.
So, bidder has come, Lordship.
He's saying that there's a bidder? No?
Lordship, the previous bidders have given it on an online portal, and this time also we had gotten online portal bid. I had already forwarded this to her.
This is your report. So who has carried out this exercise? You have carried it out. The receiver has not carried out the
Lordship,
exercise.
there was a publication made by the receiver. Thereafter, an online bids have come in.
All right. So they have you don't have information about it.
We have already, Lordship, we have updated her everything.
We got the copy.
All right, take now. Peruse the report of the receiver. There are two vehicles, huh?
There is only one.
One vehicle. Why do you have these are two reports?
Lordship, one is the updated report.
One for vote and one.
Oh. It's not mail. I had forwarded this to you.
Peruse the report. Report filed by the receiver is taken on record. Perusal of the report indicates that an advertisement was duly published in the newspaper for auction sale of the. This is a car.
Lordship, it is a vehicle.
Auction sale of the vehicle on 9/2/2026. Full stop. Though the report indicates that no bidders came forward and the bid remained and the auction remained unsuccessful. Full stop. Though the learned counsel for the petitioner, award holder states that they had received the bid on the online portal and the same has been communicated to the learned receiver. Full stop. The receiver is directed to conduct the sale proceedings in terms of the bid received by the petition on the online portal. A copy of the proceedings carrying out the sale proceeds shall be filed on the next date. To the whatever it is, execute
Lord,
it and
the
file it.
order by the court is necessary for confirming the sale against this person. Then she can take the procedure. Lordship, I'm giving the 743252.
जहाँ वो लिखवाया ना उसको थोड़ा चेंज करता हूँ. Learned counsel, the petitioner
And this is the
given-
mail communication.
had stated that she had received that they have received a bid on the online portal. Full stop.
Lordship, if Lordship comes to page number 3 of that email, there's an email saying one bidder is interested for the mentioned vehicle at the rate of 12 lakhs. And then the details of the bidder is given in the subsequent mails. The name of the bidder and the address of the bidder.
The receiver shall carry out the sale proceeds in favor of the bidder, Badanath Chakravarti, and file a report on the next date. She'll carry out the sale proceeds in favor of the bidder. File. What is this GA?
Lordship, the GA was for the confirmation of the sale, so that prayer becomes infractuous now. Lordship, another prayer was that they have not filed any affidavit of assets, though there was.
One is dismissed as infractious.
Lordship.
Is not pressed, and the same is dismissed as not pressed. EC will appear after
Lordship,
weeks?
3 weeks.
After 3 weeks.
3 weeks.
After 3 weeks.
weeks. 11.
But
My lord, in
11,
this
12, and 13, my lord, I appear for the award.
I'm appearing for the judgment data, my lord. In paragraph 9 of the execution application, my learned friend has mentioned that the application for setting aside the award was filed by the government, my lord. The principal amount, it appears, has been paid in all the 3 matters, my lord. But what is the status of the Section 34 application filed by the state of West Bengal is not there.
You are appearing for the state of
Yes,
West
my
Bengal.
lord. So, my lord, I'm just kindly give me 4 weeks time, my lord.
I'll
file my
indicate
affidavit
to your
also.
lordship. My lord,
So
but
the
on the
particular
last occasion, my
they
lord,
are-
my learned senior friend said that she will take instruction.
We have
My lord,
not as yet
no
because
instruction at all. My lord, I'll indicate. My lord, as on the date of filing this execution application, a Section 34 application was pending. Thereafter, in the Section 34 application, affidavits have been exchanged. It was ready for hearing. Then, my lord, there was a confusion as regards the rate of interest which has been awarded by the award. Now, my lord, we took out an application under Section 34(3) for remanding it back to the arbitrator for clarifying on the scope or the purport of the interest which has been awarded. The learned arbitrator clarified that. It has come back to the court. Now, Section 34 application is ready for hearing. On the last 2 occasions, the learned advocate of the state.
Just a minute, madam.
Section 36 dismissed. Section 34 on the last 2 occasions, learned advocate for the state appeared and said that there is a change of panel. I can't argue. And this is why we are pressing this execution for. They are keeping the Section 34 pending, never doing it on merits. And that is when, and now in execution also, they want to seek instruction what is going on in
my lord,
34.
so far as Section 34 is concerned, my lord,
Yes.
I have come to know about this only from paragraph 9 of the execution
Very
application.
good. You have done a
Now,
great
Lord,
job.
if my learned friend can supply
What
us a
about the
copy.
instruction? You had sought time last time to
I
take
know, my lord,
instruction
but
from
we
the
have tried
department.
to ascertain, we have not been
What do you
able
mean
to.
tried to ascertain?
You know, Section 34 application, if it has to be
What do
heard,
you
my
mean
lord,
by
let's do
tried
the.
to ascertain, madam?
Well, there has been a change in the panel. The documents are not there. We have not received the document from the erstwhile advocates, my lord. This is the situation. The fact which my learned friend is
How
submitting.
long will the court suffer because there's a change in the panel?
My lord, I will not take. I'm not seeking for adjournment. But if my learned
We are
friend
not concerned with the change in the panel.
my lord, if my learned friend supplies me the copy of Section 34, my lordship fixes a date. We will argue. I will not take time, my lord. I'm not in a habit of taking time on this ground, my lord. But your lordship kind of appreciate we are handicapped. Where we don't have documents, erstwhile advocates have kept the
This is an
documents.
execution petition.
Yes.
So you forget about the 34 petition. You tell me this.
No, because if the my lord section, whatever the facts which my learned
There
friend
a
has
stay in
stated, my
34?
lord, well, I am not aware. I've come to know of the Section 34 from paragraph 9 of my learned
36
friend's
was
application.
dismissed.
34 was dismissed.
36 was dismissed.
36 were dismissed?
Yes.
For what?
Well,
But
the
it is
court,
not
court
mentioned
felt
there.
it. Well, it is the opinion of the court. Nobody challenged. Court felt that since the execution is pending before this court, that court can't grant stay of it is pending before the Alipur Commercial Court. It was of the view of the court that since execution is pending before High Court, I know, well,
Absolutely.
this is, I
But
know.
this is the right
Well,
legal
they have not challenged, although we have also not challenged. We were minded to thrash it out on merits on the Section 34 application. And in the 34 application, they are taking time every day.
If my learned friend supplies us a copy, my lord, of the section 34, my
Yes.
lord, we will argue the matter, my lord. It is not so that we are not willing
So
to
we'll
argue.
attach the money. For the time being, we'll attach the money.
My lord, so far as the principal amount that has already been paid, admittedly in
we have
paragraph 9,
stated that
they
in
have
the
admitted.
application.
Therefore, my lord, let us contest the section 34, my lord. It is not that the state of West
34 is
Bengal is
running in
there,
the
my
list.
learned friend's interest
So
is
it is
protected.
next fixed for them.
When is the next date?
Sometime this month it is fixed. It has
If my
been
learned friend
going on
gives us
for.
the particular of the cases, we can try to obtain a copy, my lord.
I can give the cases,
Particulars
but
are not
for how
given.
long will this go on for?
Paragraph 9, you have not given the particulars,
Court-
otherwise we have ascertained it.
At that point of time, it
Kindly
was
help
only
us.
pending. Nothing happened at that point of
Last
time.
time also, madam, on 18th of June, you made
Lord,
the
that
same
was the
statement.
same day we were briefed, my lord. And thereafter, we have tried to ascertain the details of section 34. These are not
What are
available.
the details?
If parent friend gives us the copies also, my lord, it will be very helpful.
I shall give
Take the
everything.
copy from.
Yes.
We'll have it after 2 weeks.
Well, 20th August is the next date before the commercial court. For hearing of the
So
section.
kindly give us slightly longer date so that we don't have to come and seek time, my lord, from your
Pendency
lordship.
of 34 has never been a bar to execution. There is no stay. Lordship may pass some order so that.
Nothing in here. What will I? You have already received half the money.
I have received the principal. This
Then-
execution is only for interest.
Interest,
Nothing
we'll
else.
see. The 34 is still pending.
That Lordship may record something or the other. Otherwise, my lord, the state will never do the matter.
Learned counsel for the respondent award letter. States that seeks and is granted time to take instruction. List after 4 weeks. List in the monthly list of August. We'll see.
Lord, I request my learned friend to provide me the copies, my lord, of all section 34 at our
Kindly record that in the order, because otherwise somebody else may appear before the commercial court and say
No,
that they
it
have
will
no
be served
instruction.
upon the office of the learned
I do not know
AOS.
that what happens.
Advocate
Learned counsel
record.
for the award letter states that since there's a change in the state panel, copies of the 34 petitions and the pending cases shall be handed over to her. Learned counsel for the award letter undertakes to supply the same within a period of 1 week.
Grateful.
In all the three matters.
11, 12, and 13. Grateful.
Separate orders.
Item number 14.
Lord, in item number 14, I appear for the award data, my
Lordship, I appear for the award holder, Lordship. I have taken out an application for condoning the delay in furnishing the bank guarantee, Lordship. The bank guarantee had expired on 30th April 2026, Lordship. I had expired on 30th April 2026, Lordship. I had received a letter from the registrar on 27th April 2026, Lordship.
Page.
Lordship, I have not annexed the letter from the registrar, but I have pleaded that at para 14. Lordship, on 4th May 2026, I had received the renewed bank guarantee from the bank, Lordship, with an increment of 5%. I was supposed to tender this.
The present application has been preferred by the award holder seeking continuation of delay in renewing the bank guarantee. Number, यहाँ चलो, page 13. 006 NDD G 000300124. Dated 28th April 2023. Amended on 4th May 2026 and for leave to furnish the said amended bank guarantee before the learned registrar original side in regularization of the order dated 2nd May 2023 passed in the instant execution petition. Full stop. Let counsel for the award holder submit that being aggrieved by the arbitral award dated 20th June 2022. The award data had preferred an application under section 34 of the Arbitration Conciliation Act, registered as EP number 684 of 2022, which is still pending adjudication. Full stop. The award holder had preferred an application for partial setting aside of the award in AP Com 275 of 2024, which is also pending adjudication.
My lord, our AP com is 276, my lord.
That is the earlier number.
That is the new number. AP com number 276 of 2024 is
The new
our
number is 684.
no, that is a mistake that has been made in the petition by them. Our new number is 276, my lord. AP com 276.
684 किया ना 276. It is submitted that since there was no stay of the arbitral award, this court-wide order dated 11th November 2022 had attached the award debtor's bank account to the tune of 10 crore. Thereafter, the award debtor had filed an application under section 36(2) of the said act for enforcement of the award, registered as AP 771 of 2022. For stay of the said award, not enforcement, stay of the said award in AP 771, right?
771, yes.
771 of 2022. And upon the award debtor showing willingness to deposit 15 crore in cash before the learned registrar original side, this court-wide order dated 16th November 2022 vacated the attachment upon the deposit being made. It is submitted that the award debtor complied and deposited 15 crores
Yes, ma'am.
with the learned registrar original side. Full stop. The award holder applied for withdrawal of the said deposit, which was permitted by order dated 2nd March 2023, subject to the award holder furnishing
Bank guarantee.
a bank guarantee of an equivalent sum, the satisfaction of the learned registrar. In compliance therewith, the award holder furnished the original bank guarantee dated 28th April 2023 for 15 crore through इसको बंद करो through ICICI Bank Limited and withdrew the amount as recorded in the order dated 18th August 2025, disposing of AP 771 of 2022. Full stop. It is submitted that the said bank guarantee was initially valid for a period of 1 year and has been extended from time to time in compliance with the order dated 2nd March 2023. Full stop. It is submitted that prior to expiry, the award holder had taken steps to extend the bank guarantee. However, the concerned bank, by email dated 30th April 2026 sought an additional board resolution for enhancing the amount of bank guarantee. Full stop. The award holder had clarified that no fresh board resolution was required for the enhancement since it was in compliance of the court order. But the bank had insisted by email dated 2nd May 2026, to which the award holder had duly responded, reiterating the board resolution already stood submitted at the time of the original issuance. Full stop. It is submitted that 1st May 2026 being a Labor Day, and account of the holiday, the bank had remained closed. Full stop. It is submitted that the original bank guarantee dated 28th April expired on 30th April 2026. 20th April 2023 expired on 30th April 2026. And on account of the aforesaid circumstances, could only be renewed on 4th May 2026, extending its validity till 30th April 2027, with a further 12-month claim period ending on 30th April 2028 for an enhanced sum of 173643750 in terms of the order dated 2nd March 2023. Learned counsel for the award holder further states that he had received a communication from this court dated 27th April 2026 regarding expiry of the bank guarantee. Full stop. It is further submitted that the renewed bank guarantee was received by the award holder on 5th May 2026, and the same was tendered before the registrar original side on 6th May 2026, wherein the learned registrar had declined to accept the same on the ground that it had already expired. Full stop. Learned counsel submits that the delay in renewing and furnishing the amended bank guarantee was neither deliberate nor intentional, but occasioned by circumstances beyond the control of the award holder, namely the intervening bank holiday and Sunday, coupled with bank's insistence on a fresh board resolution, and that the delay is purely inadvertent. Full stop. Having considered the facts and circumstances stated above, and on the perusal of the material placed on record, this court is satisfied that sufficient cause has been shown for delay in renewing and furnishing the bank guarantee dated 4th May 2026, and that the said delay was neither deliberate nor intentional. Full stop. Accordingly, the present application is allowed, and the delay in renewing and furnishing the amended bank guarantee dated 4th May 2026 is condoned. It is directed that the award holder shall deposit the said amended bank guarantee dated 4th May 2026 with the learned registrar general original site within 1 week from date, and upon such deposit being made, the same shall be treated as valid, subsisting and binding in regularization of the order dated 2nd March 2023.
Obliged,
Till
Lord.
the instant execution. Yes.
Like-
With the aforesaid, the present application stands.
Beautiful.
$15.
But this is really the execution of a arbitration award.
passed under the MSME Act.
What is the application?
The award which was passed by the MSME Council has not yet been complied with by making payment. Though appearing before the court, they once said that we are just seeking time to make the full payment.
Yes.
They have not done, they have made certain part payment. I have given the detailed accounts at page 31. Now still, my lord, 9 crores and odds are due and payable in terms of the decree, in terms of the award.
9 crore 6 lakh 71.
Yes. As on 31st, original calculation is still 31st. Original award original award 10 of the application. Page 10 of the application.
This is the application filed by
Us. Filed by, my lord, by the award holder, MSB Laboratories. I'm not
Yes,
the only.
sir.
The award has been passed, principal and interest. Total principal has been paid up.
Yes.
Only the interest is due. And they have prepared in calculations, the date of award, date of the bill. They have come with an calculation. Give a short time, we shall come with our application, whatever order they
Very well, let them file affidavit.
Our calculation will come with before lordship. Then my lord, thereafter my lord pass the order. Principal has been paid up total.
Well, naturally, the interest will go up.
In short time, not
Let them file an affidavit.
So what happens is every time I'm not asking long time.
Then this goes out of the list and then this accumulation fees keeps in.
Learned counsel for the awardator. He seeks and is granted
Let's fix a date.
2 weeks time to file his
Continue 2 weeks.
calculation regarding the interest to be paid.
Not only the interest, blood, the total amount to be paid in terms of the award.
The total amount
Principal
to
amount
be-
in terms of the
to be paid in terms of the award,
principal amount.
including the principal as well as interest.
Principal amount has been paid up. That place that
Including if any
that has been
principal,
recorded, show the order.
including if any principal amount is due and the interest amount to be paid in terms of the award. Let the calculation be filed on the next date. List after 3 weeks.
3 weeks.
After 3 weeks. We'll see the whatever the amount is according to them.
Yes,
Then we can.
But it could have been sorted out. Not the government organization.
It could have been sorted.
Unfortunately, they are dealing it. With a few weeks. Now, may a particular date be fixed subject to court's convenience?
Give a date after 3
At the date will show that. 30th.
30th July. My execution application, Lordship. The award of 2019, Lordship, the section 34 was dismissed in 2022. Appeal was dismissed in 2025. Thereafter, Lordship had passed an order. Lordship recollects that there was a miscalculation in the this is that matter.
lot of
Yes, lot of lot of mistakes in that error in typing.
Who's on the other side? State of
Nobody is appearing since then.
Serve them, serve them.
I have served twice also. There nobody is appearing.
To serve the AG's office.
I'll
Will appear. You know there's a change in brief.
I after that also I did, but I'll again survive.
To serve them.
25 the section appeal was dismissed. Thereafter I'm waiting for the
But somebody has to be there to get it executed.
and the department have filed a calculation. What is the amount? There that particular paper is there with us.
Learned counsel for the none appears for the respondent. Learned counsel for the award holder shall serve upon the respondent's office. Mr. Shibu Shankar Banerjee, who is present in the court, is requested to. You'll appear.
I will not appear. I will ask the advocate on record of state
Requested
government.
to intimate the office of the Learned Advocate General, so that the matter is
after a week,
represented on the next date. Represented by your state council on the next date. Give after 2 weeks.
1 week, Lordship. Kindly.
Give after 1 week.
Highly.
আমাকে ডিটেলটা দিয়ে দিস লাস্ট অর্ডার ডিটেল
You are for the state, right? You appear.
Yes, Lord. Now I.
उसमें एक line उसमें add करना रिया. Mr. Shibu Shankar Banerjee, who appears for the state. लिखा ना Shibu Shankar Banerjee, who appears for the state, is requested to.
Well, this is a matter where my learned friend has taken a point that the award which he received is without signature, and so it is his 120 days clock has not started. Lordship, I have placed the recent judgment of this court of the single bench of Justice Shampa Sharkar, where I said that similar question arose before this court. The court has decided that no, even a certified copy served upon you is a good, or the postal receipt which shows that it has been dispatched in your name is good. And to verify such, the court has the power to call for the record from the MSME office. This is first point. Second point, whether I will have a jurisdiction at Calcutta High Court or not, that was he argued. Against which I said that, of course, if I am registered at Calcutta, wherever I go, if I want to invoke MSME, I cannot go to Bihar to invoke it. I cannot go to Hyderabad to invoke it. Because MSME facilitant center is only available to me is this place. And if this place is within the jurisdiction of the concerned High Court, will have a jurisdiction over it. These 2 points I argued. I placed my judgment before your Lordship. He is today supposed to give me reply on that.
Your Lordship has the copy. I will first deal with the Justice Shampa Sharkar's decision. Your Lordship has the copy of that judgment, JD Electrical Products versus Purvachal Udyog.
ये देना. Yes.
Your Lordship will come to paragraph 29. This is factually distinct. Your Lordship had also pointed out to my learned friend the last time. This is factually different.
Page?
Your Lordship,
29,
SCC,
postal receipts.
Postal receipts, page 13, SCC on paragraph 29.
Yeah.
It says the postal receipts have been annexed to the arbitral records showing dispatched of the signed award to both the parties and thereafter. The thing was in this, and if your Lordship reads through the thing, dispatch of the signed awards to both the parties and thereafter dispatch of certified copies of the signed award to both the parties. My allegation here and objection was even the execution petition, the award which they is being relied upon is an certified copy of the unsigned award. It is not a question that they have certified a signed award. It is a certification of an unsigned award. That is not permissible. This judgment is not an authority that a certification of an unsigned award is correct. Because the thing which was being decided upon here, rightly decided that certified signed awards were sent. They have certified signed awards, copies of signed awards. Now, all of this will be put to rest, your Lordship. Just give me 1 minute. I'm giving my learned friend a copy also. Your Lordship, this is a 2016 Government of India, the Government of West Bengal circular, which are the rules with regard to these MSME proceedings. And your Lordship I will refer to 3. Your Lordship comes to internal page 79.
and rules 8 and 9 I'll show first. 9 I'll refer to later on, but Your Lordship, 8, conduct of arbitration proceedings. It says when conciliation process as per section 18(2) does not lead to settlement of the dispute, the council shall enter itself as an arbitrator for the final settlement of the dispute or any institution or center providing alternative dispute resolution service in accordance with the provisions of the Arbitration and Conciliation Act 1996. So the entire council has to act as per the Arbitration and Conciliation Act, including section 31 and whatever the mandates of that. Your Lordship, the second part is where I will show the judgment later on, the explanation of this. The second is place of arbitration. That's rule 9. It says the place of arbitration shall be determined. That should have been the sheet anchor, that this says perhaps the place is here. But that was also argued, and that in the judgment in Calcutta High Court has said that has nothing to do with your case. Any matter with regard to 34 or enforcement has to go by section 21E of the Arbitration Act and not by this rule. I'll show that judgment. Now your Lordship will come to rule 16 in paragraph 81, internal page. Your Lordship sees now form and contents of the arbitral award. It is there. This is MSME regulation now. The council shall make an arbitral award in accordance with section 31 of the Arbitration and Conciliation Act 1991. And thereafter, rule 5, if your Lordship just goes to rule 5, after the arbitral award is made, a signed copy of the same shall be delivered to each of the parties within 21 days from the date of the arbitral award. Never done. Also, rule 2, an arbitral award shall be made in writing and shall be signed by the members of the council. As of now, your Lordship, both the parties don't have a copy or a certified copy or the original copy of a signed arbitral award. And that is a stated fact. These are regulations which are already there. Now, I have already sent 2 weeks back. We have, before your Lordship, last month, we had sent all these judgments which we will rely upon to my learned friend. Odisha Power Generation Technical Consultant and parties mail করে দিয়েছি আমি আবার দিয়ে দিচ্ছি আমি দিয়ে দেবো কপিটা Your Lordship, in this judgment
You'll take some time, right?
Your Lordship will take 10 minutes.
I'll just come.
Very well. You know, at 12 I may be excused because
The junior is here.
take 30 seconds time of my learned friends with permission. What we are arguing before your lordship today, we are trying to say signed copy was never signed. We have never dispatched. So the entire argument of both sides revolves around the one fact that whether it is actually existed in their office or not. It's not a case, please. Now, Mundu Nadasna disturb. So what I say is, let a report be called from the MSME, whether actually copy is there or whether actually they have dispatched or not. Based on that actual fact, we should argue that if they have done, then of course I have a case to argue. If they have not done, I have no legs to stand in the court. I feel this. And if he says no, these two matter no relevant, then lordship, he should consume the time of the court.
I will indicate, your lordship. I will say it is not relevant because the act of sending and a signed copy is what it is 31.5 is all about. And my time, whether there is actually a signed copy or not, is not relevant. What they have sent me, that is relevant. And your lordship, this is I have shown it to my learned friend, has also read this, the judgment exactly on the same facts. Exactly on the same facts. Decided by the Himachal Pradesh High Court. Your lordship will come to internal.
You had shown Odisha power.
I will come back to that. This one is because this issue has been raised. I'm just answering this and thereafter I'll come to that. Paragraph page 13, your lordship, on the conclusion. Exactly same mode was being done here. In this case, your lordship, what had happened was the MSME council did not decide the arbitration themselves. They appointed an arbitrator. The arbitrator, after deciding an award, did not send it to the parties, sent everything back to the MSME council, the papers. What after the MSME council, what they did was, they did not send the signed copies, but the copy of the award only certified by them to the parties. When one of the party challenged it in 34, the court said, this is not a signed award, I will not entertain your 34. At that point of time, this petition was filed and it was decided. Your lordship will come to page 13, the conclusion. The procedure adopted by respondent number 3, that is the MSME, because it's a writ petition, MSME was made a party, for supplying the copies of the arbitral award to the parties is not in consonance with the procedure mandated under the Arbitration and Conciliation Act. It is an admitted case of respondent number 3 that the signed copy of the arbitral award was not supplied to the petitioner and only a copy of the award certified by it, MSME, is the next page, your lordship, was supplied. This is the exact facts of this case also. Hence, there is no escape from the conclusion that provisions of section 31(5) of the 1996 Act have not been complied with. I'll just add the next part of the paragraph. During the hearing of the case, while showing the record, it was candidly admitted on behalf of the respondent number 3 that same procedure is being adopted by it for supplying the arbitral award in other cases as well. Such practice being not in consonance with the mandate of the 2006 Act as well as the 1996 Act cannot be countenanced. The parties are to be provided signed copies of the arbitral award. The arbitral award is to be made available to the parties by the arbitrator himself in accordance. Here will be the MSME Council because they have decided in accordance with the provisions of the Act. Your Lordship, this much. So the problem here is twofold. One is under section 36 and one is the judgment which had explained that provision, the Haryana Vijli judgment which I had referred to. That judgment said that the mandate of section 36 of the Arbitration Act is that no execution application can be entertained prior to delivery of signed copies. The reason of that is till both the parties, not only one, both the parties receive the signed copy of the arbitral award, the arbitral proceedings have not terminated. Just because MSME Council may have signed somewhere and kept it with them without giving copies to both the parties, signed copies, that doesn't mean that today somebody can and say that that will validate this execution proceeding. This execution proceeding, Your Lordship, to my submission, is at this moment can not be entertained by any court because both the parties have not received their signed copies. And Your Lordship, the glaring aspect of this is that execution has been filed itself with regard to a certified copy, unsigned certified copy. And this is, Your Lordship, various execution applications which are there, which are going on like this. Now, coming back, Your Lordship, my other point, I don't want to elaborate more on this because I think the judgment as well as the regulation and all absolutely cover this aspect. The other aspect is with respect to whether this court has jurisdiction or it is some other court which will have jurisdiction to entertain even a execution or a 34. Your Lordship will come to that. The Odisha power generation was technique, the judgment which I was referring to of this High Court. Read with section rule 9 of the regulation which I had provided, which talked about the place.
Yes.
Your Lordship sees. Comes to paragraph 13 and rule 9. Rule 9 is in internal page 79 of the regulations, and paragraph 13 is in page 4 of the judgment. Rule 9, Your Lordship will see in paragraph 13 is referred to and set out also. Yes. Page 79 of the regulations and page 4. Rule 9 is being set out. Thereafter, paragraph 14. The petitioner award debtor relies on Rule 9 to argue that the council assumes responsibilities of deciding on place of arbitration, or in other words, obliterates any chosen seat of arbitration which the parties may have decided earlier. The petitioner's argument, however, disturbs the underpinnings of arbitration as an appropriate dispute resolution mechanism underscored by free and informed choice. The parties' agreement to a designated seat or a venue agreement to a designated seat or a venue for the arbitration serves as the base document for all future adjudication in the courts. The arbitration cannot be unseated simply by statutory arbitration under the provisions of the MSAD Act, and in any event is meant to last till the Facilitation Council decides on the reference so and so. Your Lordship will then come to paragraph 29. And this is the most important aspect because unlike the case which I'm referring to here, in our particular case at present, there was no designated seat or place which was decided. In this case, it was. What happens in that case? Paragraph 29. The framework of section 18 makes it clear that the legislature intended to clothe the Facilitation Council with the powers of an arbitrator only for the limited purpose of adjudicating upon the reference under section 18(1) and for the necessity of grounding the adjudication on a statute, namely the Arbitration and Conciliation Act 1996. Any question, including that of enforcement or setting aside of the award passed by the Facilitation Council, would be decided by the court under section 2(1) EI of the 1996 Act. As stated above, section 19 of the MSME Act only operates on the mandatory requirement of 75% deposit to be made by the applicant before the appeal application is entertained by any court. So the question of enforcement, which court will decide, and is based on 21E and not where the MSME is situated. Whether they are registered under this MSME or Odisha MSME or someone somewhere in Maharashtra is not germane. What is germane is under 21E when you examine the transaction, underlying transaction which has come to the MSME Facilitation Council, under that how they are placed. If that is here, it would be here. But unfortunately here, this case, the transactions or all the banking transactions, nothing happened in the state of West Bengal. Everything happened in Telangana. So this court does not have appropriate jurisdiction just because the MSME Facilitation Council had decided this. And all the judgments from Balco, Gujarat Supplies, all of them have been listed out. Your Lordship will see paragraph 34 and every judgment on this point, this case has taken care of and referred to all of those judgments and then decided it across. So, Your Lordship, these are my limited submissions on these 2 points. As and when the arbitral award waiver is placed, I will make some further submissions on how it cannot be enforced thereafter also.
So according to you, even the award itself is an honest award, because if it is not signed, not delivered,
it is not.
Right?
No.
It doesn't fit into the criteria.
Your Lordship, may I just indicate why sometimes what happens is, I'll tell, to be on, I should not mislead the court. They say MSME Council, what they do is, they have done in the Himachal case also, what they do is, they have a copy of the award which is unsigned. They don't give the copy of the signed award to anyone. The unsigned copy that they certify and circulate. That is what is happening. But if they have signed or not is a big question. And the bigger question is, this is a long, old MSME award. If it has not been signed, those persons are no longer there in MSME Council anymore. How can that be they sign now? They cannot sign now because those are statutory positions. All these things come up here also. All these facts come up. But at this moment, my basic thing is, this court is not a court under 21E, could not have entertained, cannot exercise jurisdiction, one, and the otherwise also, no execution application at this stage can be maintained because my period of 90 days which is given under section 36, that has not elapsed. Because till date, nobody has a copy of the signed award. These are my submissions.
Yes. Anything else to rejoin?
No, Lordship. Lordship, kindly see the judgment which he has referred.
Which one?
The last Odisha. The Lordship kindly comes to pay para 32 to the head copy. Para 32. He placed up to 29 and 30. The only possibility Lordship, he just placed Odisha power generation.
Yes.
The only possible conclusion from the above discussion is that Section 18(3) of such and such import and provision of the arbitration conciliation for the limited purpose of conduct of the arbitration, with the agreement between the supplier and the buyer being treated as an arbitration agreement under Section 7(1) of. There is nothing in MSAD Act to suggest, least of all Section 18, that the arbitration conducted by the facilitator will subsume the arbitration agreement between the parties or alter the seat and venue chosen by them. At best, the arbitration agreement is equipped during the adjudication of the facilitating council only to rise against after the council pronounced its decision. Thus, the arbitration agreement between the parties take precedence over the publication of an award by the parties. So, Lordship, here the case was when there is a arbitration clause or the agreement is with a jurisdiction forum exclusion clause. When they have a forum exclusion clause or a jurisdictional clause, it is well fallen from ABC laminator, my lord. When there is a exclusion clause, then Lordship, that agreement will preside. Now, today we have approached, my company is situated within Calcutta. I am registered MSME at Calcutta. When you entered into an agreement, you know that I am a registered company under MSME. You know that this is the facility I have with the MSME. You entered knowing fully well with me into contract. Then you defaulted and I approached. So, Lordship, this agreement, in absence of what he argued from the bar today, cannot hold. Lordship, we have to see, he has to show that this is the forum exclusion clause was there. Or else, Lordship, the forum, the cause of action was here. Party, one of the parties executed work here. So, Lordship, the agreement, unless exclude this jurisdiction specifically. When there are three probable jurisdiction and legal jurisdiction, they choose one of them. Then two are ousted. But here, unless he clearly shows that this jurisdiction was ousted by the agreement, he cannot come on within the purview of this judgment. This judgment clearly shows when there is an agreement, you decided to exclude a place, only because you are MSME registered in that place, you are invoking that jurisdiction. That's the gist of this entire matter. And Lordship, so far as the Himachal judgment which he referred to, now Lordship kindly, huh? Now, Lordship, kindly see the judgment which I preferred before your Lordship on 2018 Supreme Court, Lordship. Lordship has seen that? Lordship, Sundaram Finance, Lordship, I have given. Lordship, kindly, Lordship, kindly see Sundaram Finance. Lordship, kindly see what is the provision. Now, the provision is execution can be done in multiple places. That's the known proposition now. Now, if I come back to this 6-9, this Supreme Court Sundaram Finance, Lordship, kindly come to para 22. Lordship, we are thus unhesitantly of the view that the enforcement of an award through its execution can be filed anywhere in the country where such degree can be executed, and there is no requirement of obtaining a transfer of degree from one court to another. So, Lordship, whenever an award has to be enforced, I can file in more than one place. So, Lordship, first, so for the purpose of 2E1, what my learned friend said from Odisha, that is for 34 or 37, because there the concept is the court. If the court, that means the court will exercise the power under 37. If it is from the 37 to the district court when it is jurisdiction, or to the high court when if it is within jurisdiction, to then the court, or 34 is there, or where section 9 has been filed earlier. So that's the law. And so far as execution is concerned, then the question of particular jurisdiction, if he has got asset, suppose at Delhi, I will file execution, I will hold that asset. If he has asset at Kanyakumari, I will go file and I will block that asset.
for executing a decree or an award, I need not to have a jurisdiction. Previously, the law was the executing court used to transfer that executing case from one court to another. Now the law has changed. Now the law is settled that I can file multiple execution case and I can make. So, Lordship, that today his argument on a jurisdiction is completely fallacious in an execution case, so far as jurisdiction is concerned. And now, so far as Lordship, if your Lordship kindly come to the Himachal judgment which he...
Yes.
Now, Lordship, what was this case? This case, the fact is completely different. This case, he said that this is an REIT. Why REIT? First, they filed an application under section 34. Then they withdrew 34. Then they filed an REIT directing the council to provide the copy. Now, Lordship, kindly see the facts of the case. If your Lordship kindly come to para 2. The matter pertaining to the procedure adopted by the respondent number 3, Himachal Micro such and such. In the instant case, there was no challenge to any order passed by the learned arbitrator. The arbitrator was not under, the arbitration proceedings was not under challenge. Prayer was made only for supplying signed copy of the arbitrator award in the view of the nature of the controversy raised in
Where
the...
are you reading, Mr.
Lordship?
Which paragraph?
Paragraph 2, Lordship, page 1.
Page 2. Yes.
Thus, in the instant, there is no challenge as to any order passed by the learned arbitrator. The arbitration proceedings are not under challenge. Prayer has been made only for supplying of the signed copy of the award. In view of the nature of the controversy raised in the petition, the fact pleaded by the petitioner, admission thereof by the MSME, and also taking into consideration the general practice being adopted by the MSME Council, which is invariably resulting in non-supply of the signed copy. So, Lordship, the entire premise of this judgment, what my learned friend said, yes, this they do, this they that. Lordship, here it was admitted by them. So when Lordship was in session, I requested the court that in that case, let it be called for. That is the reason why I suggested that a report may be called from the MSME, what actually happened, whether signed copy there, not there, whether dispatched to them or dispatched to us. Unless this first paragraph is satisfied, then Lordship, we cannot come to this conclusion. Because this is the case where MSME admitted. MSME was a party, MSME admitted. He did not file a REIT. He did not file a 34. He picked up a point, he suffered a degree, he said, my time has not started. Lordship, kindly see, next, if your Lordship, 2 Roman 3. Page 3. The petitioner, feeling aggrieved against the award dated this, challenged it to by filing the petition under 34 such and such in the court of this. The petition was not held to be duly constituted as a signed copy of the award dated such and such, was not placed on record by the petitioner. During pendency of this challenge to the aforesaid, petitioner through its counsel by written communication such and such requested the arbitrator for supply of the signed copy of award. Since the copy of the award was not received by the petitioner, it ultimately withdrew the petition under section 34 of this. In the above factual ground, the instant petition has been preferred by the petitioner, seeking direction to the respondent to issue signed copy of the award dated such and such. So, Lordship, here kindly see the bona fide of the petitioner and here the mala fide of the petitioner. They did not, they understood it is incorrect, according to them. Did they write, let them not make litigations, did they write one single letter?
Writ petitions are pending, Your Lordship, because I cannot file 34. There are pending writ petitions.
Now, Lordship, then he has to show some bona fide somewhere.
And today he comes back, then he could have said that I have filed that writ petition there, it has to be seen, and then we can come back. Or Lordship can call for the record. With a very low voice, he said long back. The court must have.
I'm not part of. I was not in part of the original.
Anyway, that is also not there in this record. In his application, it has not been stated also. So I am not aware. So Lordship, if it has filed in a long back, then this question should have raised. So some court has to come to a finding, yes, this has happened, so this is not an. Only on a technical ground, what he says today, that this cannot be enforced, and Lordship, in contra, kindly see the judgment of Justice Shampa Sharkar.
Your Lordship, again, this paragraph 29 of Shampa Sharkar. This has been placed twice already.
So Lordship, here the court is categorical.
Yes. Yes.
Lordship, kindly see page 16 of page 22.
Paragraph.
Lordship, paragraph 35.
Yes.
Lordship, in such and such case, the expression signed copy of this indicated the legislative intent that the copy of the award duly authenticated by the arbitrator could also be served on each of the parties. The relevant portion is such and such. It may be noted that along with letter such and such on behalf of the tribunal to the council, the scanned copy of the such and such was mailed and duly signed. Once a duly scanned copy of such and such has been received by the petitioner at the period of the limitation purpose such and such. So, Lordship, the court recognizes how the other court has come to a conclusion, and court says that if it has been done, so it is complete. Now, Lordship, kindly turn to the next page. Lordship, upon 36 and then 37. Upon discussion of the judicial authority above, the court comes to a conclusion that the award has been served not only by applying the deeming fiction, but also upon relying a document annexed to the affidavit opposition filed by the award holder. The latter states that the postal receipt in question of delivery such and such is clear, the delivery such and such is true. Then, Lordship, they have this. Thus, this court has adequate reasons to believe at least the authenticated copy of the award, which was certified by an office bearer of council, bears the photocopy signature of all the members, has been delivered to the address of this letter. Therefore, as per the record forwarded by this council and the content of the letter dated written by the chairman of this, a signed award has also been sent to the both such and such. So, Lordship, this finding we have to come. And Lordship, I have also placed before your Lordship this National Agriculture, Lordship. সব করে দেবো দাঁড়ানো বলে কি একটা কপি বের করো দাদাকে দাও Then Lordship, kindly see straight 32, Lordship. We hold that copy of the award and the copy of corrigendum sent by the registrar of Indian Council of Arbitration to the petitioner was signed copy of the award in that they were photocopy of the original award along with the photocopy of the signature of the arbitrator duly certified by this. In our view, to start and run such and such, when the correct award was received by the appellant and the applicant for setting award become barred by limitation on such and such, the delay was condemnable only by 30.
Is the signed copies, how is this relevant?
So, Lordship, what has actually, in all cases, Lordship, we have to see what the commission has done actually. So that is the reason why, Lordship, I requested this Honorable Court to call for a record from their office and to see what has been done.
Your Lordship, may I just take 1 minute of your time, because all these judgments have been given in reply. With regard to the Sundaram finance judgment which was talked about in execution, only thing is, with regard to execution, Sundaram Finance actually says that you can file it in any place. You don't have to wait for the court under whose jurisdiction or superintendence the matter was done to get the matter transferred. You can file it directly in any part for the enforcement of an award. I agree. But for that, the next criteria is that then you have to show that they have an asset. If the respondent is based in Telangana, everything is in Telangana, how are they showing that they can enforce it within this jurisdiction? They cannot do that. So at the end of the day, again, back to square one. Now, paragraph 29 has good significance in both the matters which they refer to. The Odisha judgment, the Calcutta High Court judgment, which I showed, Technique Consulting, that paragraph 29 says that 21E will be the court which can be determined under 21E of the Arbitration Act. That will be not only for Section 34, also for enforcement. And that paragraph talks about a situation when there is no underlying agreement, where there is a specific jurisdiction clause. That's one. The other one, Your Lordship, has already, I showed you, paragraph 29 of Justice Shampa Sharkar's judgment, which clearly says these are all signed. Certification of signed copies and certification of unsigned copies are completely different things to be looked at. Your Lordship, that
Deal with all your judgments.
Eighteen. 18.
Application for execution. Your Lordship was pleased to pass an order directing us to serve the copy of the order. Order to know. Order is
Yes.
But it has come back with the postal endorsement left, but Mr. Shaha is appearing.
Yes.
They have been directed to file their affidavit of assets.
Milord, we have, Milord, got a copy of the order, Milord, from the server of this Honorable Court, but we have not received a copy of the execution application. Milord, in all fairness, since your Lordship has, Milord, passed an order, the order will have to be complied with. But, Milord, only one thing, if your Lordship sees, Milord, perhaps, Milord, this may not be necessary if your Lordship holds that, Milord, the execution application is hopelessly time-barred. Milord, award passed in 2008. This execution application is filed in 2025.
I could not have filed an execution because there is a 34 pending. Change of law came in 2015. And I will rely on a division bench judgment of this court passed by Justice Bhattacharya that till 34 is pending. But this execution has been filed, my lord, after Kochi Tasker's case came into existence. That even in pending 34, even if there is a pending 34, I can still file. I can still ask for enforcement, ask them to pay the awarded amount.
The statute of limitation requires an execution application to be filed within 12 years.
34, let them say when 34 was filed.
No, so far as this is concerned, the 12 years, 2008, 34 is filed. So far as 12 years is concerned, 12 years is long over. Now, my lord, if my learned friend says that, my lord, the previous law before its amendment,
Execution has got nothing to do with 34.
My lord, execution, that was stay of the award. That's why, my lord, section 36 was amended in 2015.
Stay of, my lord, stay of execution of the award, my lord, in the sense that, my lord, execution application can be filed, but it will not be proceeded with. There is nothing which prohibits the filing.
May I just show the law in that case? What it stood before 2015 and what it is now.
Well, let my learned friend show the law, my lord, I'll deal with it. Naturally, my lord.
First, let them comply. Let them file their affidavit of assets.
I will ask for an extension of time to do that, but in the meantime,
let them do that. Let them do that, and I will satisfy your lordship.
Let my learned friend
We will
give the
decide this on
judgment.
maintainability. We'll take up the issue of maintainability. If they are alleging that this is not maintainable, let that issue be decided.
Well, if my learned friend,
I'm not. I'm serious. Is it? Well, 36. That's why 2015 amendment came. Because it was a stay. It was a section 34 was an automatic stay of the award.
If they are raising the issue of
Well, I'm willing to. But
that
takes it
has
up
to
on
be
him.
decided.
Well, takes it up on India. I will deal with it.
Next week?
Yes.
Let's have it next
I'm
week.
very grateful.
I'm not passing any orders, not today.
Well,
let them at least comply with my
We'll
lord's
see
order.
that
Grateful.
next week.
Would it be a lordship's pleasure to pass some orders, my lord?
Next week.
Well, let them serve a copy of the execution application. I'll accept it.
Give a copy of the.
If your lordship kindly directs, my lord. Since
Learned counsel for the award debtor has raised the issue of maintainability of the present execution petition. Full stop. He, learned senior counsel, Mr. Vishnu Saha, submits that the present execution petition is not maintainable and is barred by limitation. Full stop. Learned senior counsel submits that the award is dated
2008, my lord. The
29 February 2008.
29 February 2008. And the present petition has been filed beyond the
24th March 2025.
beyond the statutory period of 12 years. Full stop. Learned senior counsel, Mr. Rudraman Bhattacharya, who appears for the award holder, disputes the said proposition and states that the present execution petition is well within time. Full stop. Let this matter be listed for hearing on the grounds of maintainability on after 2 weeks or next week.
Well, whenever it's convenient for you, Lord.
Next week?
You can do it next week.
Next
week.
Grateful.
Yeah. Yeah.
19.
Award holders led by Mr. Rahul Arya is appearing virtually.
I'm for the award holder, my lords, in this matter. It's an execution which is listed today, my lords. Now, this award is of 7th August 2024. If my lords may kindly have a look at the last order, my lords, of 14/5/2026. My lords have asked them to file an affidavit of assets disclosing full particulars of all movable, immovable properties and with a comprehensive assets in accordance with law. They have filed their affidavit of assets in after 3 to 4 days, my lords. But if my lords will look at the affidavit of assets, it does not show that they have at all disclosed their assets. Nothing, no immovable property or movable property has been shown. If my lords will see from page 5 onwards, their affidavit of assets. Page 6 will say, if my lords are there, page 5.
Yes.
In the year, my lords may see at serial number 6, my present annual income, they say nothing. Everywhere they say it's not applicable, not applicable, not applicable. Now, my lords, they say that they hold the bank accounts, but nothing, how much money is there, nothing has been mentioned. Then then they say these are the stock or shares they hold, but what is the value of shares, that they don't say. Then these are the companies, they say that they were the directors, it has been dissolved. Then, my lords, may kindly see house, property, everything, whatever they NA. So, my lords, just by the sake of filing an affidavit of asset, this is not the manner to be filed, my lords. It has to be filed in accordance with law.
This has been filed, Mr. Arya. This has been filed. They have given the details. Where are they? Are they appearing today or not?
I'm appearing, my lord. But I have filed the master summons today. There is also appearing before Lordship's court, challenging the jurisdiction of this High Court to entertain this EC application on the ground that the asset, by their own admission, the application for execution of this award, their own admission says that all the assets of the award debtor lies outside the jurisdiction of this court. The lawsuit will straight away come. And I have challenged the maintenance liberty. I have filed a master summons. My right friend, if he chose to this, he may file, he may argue the matter here and now, or he may choose to file an affidavit if he so desires, my lord. Your lordship would take up my application, my lord, my master summons, my lord, and the affidavit accompanying the master summons. Your lordship will see there the award holder themselves say that all the assets, including, your lordship will see the cost schedule in which the award debtor is living, is outside the jurisdiction of territorial jurisdiction of the Honorable Court. All the assets by his own admission is outside the jurisdiction of this court. So, my lord, if he so chooses, my lord, whatever, I am ready to argue this matter. Because we have served a copy on him.
All
Your
right.
lordship will see. Now your lordship will see.
I'll attach his bank account.
But your lordship can, but it is not his bank account. Because for the simple reason, he is only a tenant in all these places. He's a tenant.
What is he? Sorry?
He's a tenant. He doesn't have any immovable asset. How can he invent an immovable asset? He's not, it is all in its. None of the assets of immovable property lies within his custody or control or title.
All right, I'll attach his bank account.
Your lordship can attach, but that is the bank account of a company which is a tea company. And if your lordship wants 3,000 people to die off, your lordship can do so. But my bank account cannot be attached for the simple reason it is not my bank account. It is not my bank account. It is a company's bank account of which the company is not our debtor. I am a personal capacity, I am our debtor. Your lordship will see what I have assets in my affidavit of assets. And the first your lordship, in my humble submission, means whether your lordship would pass such an order in a court where I am challenging the jurisdiction of the court to maintain, to pass an award, the execution application. The execution application is not maintainable for this honorable court, and any orders passed thereon will be a nullity, in my humble submission.
We will examine that later, Mr.
But your lordship will see, it's your own admission. Your lordship will see 3 paragraphs of the EC application. Your lordship will see 3 paragraphs.
How much is the awarded amount, Mr. Arya?
Millards, the principal amount is 50 lakhs plus 12.5% interest, Millards, per annum from 2018. Now it has crossed more than 1.2 crores along with interest. Millards, if my lords will see at page number.
So in your tabular statement, it is 1,32,984.
Yes. From 13 to 2000, at page 32, it is mentioned, my lords of the award, 12.5% per annum from 13 to 2018 on 50 lakhs. The last 3-year bank statement also they were supposed to file that also they have not filed it.
Take down.
Your Lordship, your Lordship, may I only make a request before your Lordships?
Yes.
That your Lordship will also take into consideration paragraphs 6 and 6 and 8 of the EC of my application, in which I have clearly stated, and the EC application itself, which is at page 1, which is annexure A to the my application, in which your Lordship will see at
Paragraph page 26.
Yes, paragraph 26. That is his own admission in his EC application. Your Lordship will see.
What admission?
Your Lordship will see paragraph 36.
Yes.
My manager, Mr. Shukrit Mukherjee, will read the paragraph.
That will kindly come to page 26 of my GA application.
Yes.
But paragraph 36 of the EC, but the basis on which my jurisdiction has been invoked.
Yes.
I'll place it. I say that learned sole arbitrator was appointed by this honorable court and the award was passed by so and so from Bar Library Club within jurisdiction of this court. And kindly notes the last 3 lines. Immovable properties mentioned in so and so are outside the jurisdiction of this honorable court. Hence, this honorable court has jurisdiction. So, the basis is really the seat of arbitration. This, in my respectful submission, is completely contrary to the Sundaram Finance judgment of Supreme Court.
All right. You go to
That
Supreme.
Jurisdictional facts, so far as the arbitration proceedings are concerned, is not material so far as execution is concerned. And the basis for invocation is the seat, which in the execution is not a relevant jurisdictional fact. And all the assets that they have referred to by their own admission at paragraph 30, they are all outside.
All right.
Which also reiterate at para 36.
Assets are here. Residential property is situated at 12 so-and-so road, Siliguri, Darjeeling.
These are all not his own property. He's not an owner of the property. It is not his own property.
All right, we'll see all that.
He has already filed it his affidavit of assets. That is not his property. He doesn't have a property in his own name.
Very good,
He
Mr.
doesn't say so.
He has got a bank account here. We'll attach the bank account.
Because he doesn't say so that what property he holds. He only says it's not applicable.
The bank account, as disclosed in the affidavit of asset, in para 8, bank account number so and so, is attached to the tune of rupees 1,003,2,984. List after 2 weeks.
I should also pass an order on the other application which is filed before your Lordships.
Which application?
Not that is Master Summons, which is GA1, IGA1 of 2026.
Okay. Learned counsel for the award debtor has filed an application, GA1, stating that the present execution petition is not maintainable. This court is of the view that since the petitioner is residing within the vicinity of this court and
That he doesn't reside. He resides outside the jurisdiction of this court.
maintain is what has been stated here.
34 has
I'm
been
not-
filed in this court.
He does not reside with the by admission.
Is
This is outside the jurisdiction of the original
Mr.
side of
Kundu,
the honorable court.
will you allow me to dictate the judgment or not?
But I'm only trying to bring the correct facts before your lordships.
Just read your affidavit of asset.
Your lordship will see that he is not with the jurisdiction.
I live at 1182 Kalikapur,
Yes,
Mukundipur,
it is
Calcutta.
outside the jurisdiction of the original side of the honorable court. That is what I'm saying. It's not within the jurisdiction of the honorable high court, territorial jurisdiction of the original side. Kalikapur is outside the jurisdiction of the, it falls within the jurisdiction of the Shalda court at the highest. It's not within the territorial jurisdiction of the honorable court.
So you are saying this is not the 2-1E court. Then Mr. Kundu, you come, you satisfy this court on the next date.
Well, I'll come to your lordships. The lordship gives you on the next Thursday, I will be before your lordships. I will be before your lordships.
Till that time, the bank account is attached.
Very well.
Section 34, they have filed it before my lords only. Section 34, they have filed it before my lords only.
Again, my learned friend is
Mr. Arya, you be here on the next date.
Yes, my lords. Yes, my lords.
Keep it after 2 weeks. After 2 weeks, huh?
May I only make one prayer for your lordships?
The extent of that amount.
May I make one prayer for your lordships?
Yes.
If your lordship can give me a particular time to go for your lordships, then I can go at least on my wheelchair. Otherwise, it's very difficult for me to wait, go and sit down, and I cannot attend another madrasa. If your lordship can give the specific time.
Mr. Kundu, I can't do that. The rest of the matters after that.
Deeply obliged, my lords.
My lord, I 15 fixed for examination of judgment debtors
We'll
at
take it
2
up.
p.m.
Yes.
Yes, my lord, my client came, but there is a meeting fixed for demise of senior lawyer Deepak Kumar Sengupta in the bar room number 1. I could not understand whether court will continue from 2 p.m. or not.
We don't have any resolution, madam.
No, my lord. No resolution is there, my lord.
We are sitting.
No resolution.
Till the time there's any resolution, we are sitting. 2 o'clock, we'll hold the court.
Okay.
Examination of judgment debtors, item number 113, 113.
You were right, madam. No, you were right about 2 p.m. There's a resolution now.
Not to attend.
At that point of time, it was not there. Now there is a resolution of the bar
Yes, ma'am.
not to attend. So we'll just call out the matter. Yes.
114, 115, 116,
Just a minute, 115, yes.
15,
115.
50, 150.
Who's on the other side? Nobody. Take down. The judgment debtor is present in the court for examination. There's a resolution from the bar not to pass any adverse orders. None appears on behalf of the award holder.
Award data number 2, my lord.
Award data number 2.
My lord, item number 21.
Give the vote.
My lord,
I solemnly affirm that
Whatever
my name,
I am saying,
whatever
I will depose
I will depose
by way of evidence
in the suit,
I shall
speak the truth,
and
no part of it
shall be false,
shall be false,
and I shall not
I shall not
conceal anything.
and conceal it.
Your name, sir.
Varun Mehra. Bridgemoon Mehra. Huh? Lately. My age, 49.
Occupation.
It was business before, at the moment unemployed.
Residential address.
21 by 63, C Pearl, Bandra, C Pearl, Bandra Reclamation. Bombay 4,50,000. Then
We'll have it after 4 weeks, 2 weeks.
So, sir, I am suffering from chronic diabetes and chronic chest infection. So I would
the payment. You don't have to come.
no, sir, yeah,
The payment. You don't have to come, sir.
Sir,
Just clear all your dues. You don't have to be here.
Okay.
My lord,
All right.
my lord, he is seeking 8 weeks time.
No, can't be given.
My lord, kindly
You make the
allow me.
madam make the payment. You can seek all the time in the world. All right. This is execution proceedings. Take it seriously. When you take the money, you don't think about your ailments. Sorry. Keep it after 4 weeks.
নামটা দিয়ে যাবেন 160, 116.
I am appearing for the award holder.
Nobody is here today.
117, 118,
All right, so
119.
there's no
My lord,
point.
119 in any event, I was going to ask for time as I've not been able to complete the service, my lord.
So
Even
nobody-
the advocate who has filed the affidavit of assets, my lord, he declines to take service because he is not able to connect his client.
All
So I have to serve, my lord, in some other addresses.
Rest of the matters later. Nobody is appearing from the bar. So.
Should be in 123 and 123. My witness is here. Today's is for examination of, but the
I know, but
yes,
short resolution. You want to do it? Do it.
yes, no, I don't want to. They will cross-examine my witness.
You want to do it? Who wants to cross-examine?
I'm the petitioner is
Not here.
Lordship. Next.
That's why I'm waiting outside. May I call them?
We have already released the amount.
Release the amount.
That's why
Today in the evening or tomorrow they will get that.
Wonderful. Then we'll keep it next week. Keep this matter next week. Item number
123.
You're on the other side, right? 126. Who's there? Petitioner.
I am
You're the petitioner. So we'll keep it on next week, Thursday. All right. Next Thursday we'll finish it off.